Okay, I'm happy that the audience today is going to. We are going to this workshop on the protocol on fair compensation in cases of legitimate changes, and I'm doing the introduction. And there are 4 speakers who introduce the subjects. And I first want to say as a short introduction on what we're going to do, that we are recorded right now, and here, Nick is our technical person who is doing the technical things that allow us to be on YouTube. So that means that the house rule doesn't apply. Everything that you say will be used against you. Everybody can join us here, and that's lovely, I think. But let me introduce the subject for this afternoon, and land governance multi-stakeholder dialogue. Everybody knows the voluntary guidelines, and the voluntary guidelines were established through a process of stakeholderism. That means that all kinds of organizations were involved in developing the voluntary guidelines. And the Dutch government was interested to give a lot to follow the path of multi-stakeholderism and try to open a dialogue on land issues as it was foreseen in the voluntary guidelines, to establish a multi-stakeholder dialogue in the Netherlands. And this happened, and one of the outcomes is that we want to focus on the study on fair compensation in cases of land use change. This was one of the outcomes, and so this project is commissioned by the Dutch organizational committee of the Dutch Land Governance Multi-Stakeholder Dialogue. And it was carried out by a consortium under the management of 2 parties. Now, the authors of this input document, and the input document was made available in advance to all of you, the authors of this input document came mainly from this enterprise called True Price and some other people. And the Rethinking Expropriation Law network was involved through me, because I contributed also to the development, the writing of this document. And we received also some contributions from other experts in the field. About True Price. True Price is a social enterprise that aims to contribute to the creation of an economy that creates value for all. And do so by helping organizations quantify value and improve their impact on society. This organization tries to develop tools by which you can actually calculate what a product costs in reality, taking into account also the environmental costs, for instance, taking into account that people that work to produce products should have a decent salary. And that's a method that is, I think, unique in worldwide, because they are actually helping companies to more or less get more and more of the value. Rethinking expropriation law, and we are all sitting here. I don't think that I have to explain this network. It's already done 3 conferences in Rome, in Rome, and in the Hague, and this one is the 4th one, and not the last one. It is all based on the voluntary guidelines that I introduced. The voluntary guidelines give a framework for land rights issues, which is the outcome of a multi-stakeholder process. I mentioned it before. It acknowledges that under some conditions compensation is necessary and it should be fair and just. Okay. Voluntary guidelines do not define further what constitutes fair compensation. And we want to fill that gap with developing a protocol on fair compensation. That is essentially our goal. That's the long-term goal project. To develop a protocol through a multi-stakeholder process on requirements for fair and rightful compensation for changes in land tenure. This is easier written than actually done because developing protocol means that you need to involve lots of organizations and lots of experts, and you need to do it worldwide. That means that you need to prepare very thoroughly. And the first step is producing this input document. This is early. But to develop it, the research and gathering input from all experts all around the world, in the Netherlands, and then draft and revise the document, and finally the design for law. And we are actually now in this last stage. The writing was done, as seen before, mainly by people from the good side. If you look at this slide, you can see that we just are arrived at the end of the first phase and the beginning of the second phase. There are in total 4 phases to establish this protocol on fair compensation. The next phase will be to do the groundwork of the protocol, then the shaping of the protocol, and then finally the operationalization of protocol testing and what's very important, also the public consultation. And then the protocol is there. But we have to decide when we will go on. The Dutch principal will decide on this question, but they will decide upon the outcome of this conference and also the comments we receive on the document. So that's why now we have to work on the introduction. This thing will probably be taken next year in January, February, and then it might be that we get a green light to do that. But it means also that, as a consequence, to involve more people, more organizations, and this will also need some funding. What are the goals of the protocol? Yes, establishing of minimum requirements for standardization, setting out good practice principles in the process, and aiming for legal change all over the world. The success criteria of the is adopted in the international and accepted as international official guidelines. Usability of practice should be used and it should be usable. We need to look very carefully to fair compensation cases. And compliance and complementarity to existing guidance and regulations. That must be comprehensive. Now, scoping the protocol. It's about asking you to give us input on this document, so that we are able to find the protocol. to fair compensation. Everybody knows that genuine public purpose and two expropriation. On the basis of the general public purpose and on the basis of the due process, we can conclude that there is a justified expropriation that we, where people need to be compensated in a fair way. Compensation is necessary. The voluntary guidelines say that it's fair, but there is no agreement of fair compensation. There is uncertainty, and it might also cause conflict. Fairness of compensation is not only a matter of valuation for size of compensation. It entails more. We've had some discussions and presentations about this already during the conference. First, we need to identify the problems. Questions. What are the problems with how compensation is fairly determined and delivered? And secondly, what type of guidelines would you like to see related to determining and delivering fair compensation? Let's look at the problem and the solution for it. The characteristics of the problems we encounter in the question. A lack of satisfactory legislation and guidelines are gaps. Failing to recognize existing legislation and guidelines. There are legislations that are not applied in practice. And finally, failing to implement the first group of problems are that there are the prerequisites of fair compensation, meaning genuine public purpose and due process. Now, it's not at the center of the input document, but we were advised by lots of organizations that it is important that fair compensation is not used as a kind of excuse for expropriation. That there should be always a genuine public purpose, and that there should be always a due process. So I think it's important to emphasize that this has been one of the major point of discussion when developing this input document. Then there's a second group of problems. Who to compensate? Which losses should be compensated? What forms of compensation are appropriate? Finally, how should the amount of compensation be determined? These are very general questions, and you have to break them down. What stakeholders might benefit from this development of a new profitable and fair compensation? First of all, affected individuals and communities. Secondly, national, regional, and local governments. Civil society often say, but also companies and investors to seek guidance on their investments and their activities. And also donors and developing finances. So here you see the multi-stakeholder in the project. And here you see also that it is quite difficult to follow this path of multi-stakeholderism because you need to include all these organizations, all these people, and how are you going to do this? That's difficult. Yeah. And that's not for now, but dozens of fair compensation. Not to mention the World Bank, not to mention the Food and Agriculture Organization. In those organizations are also very important, and we'd like to include them also in the organization of the drafting of the software. Now, in the document, we need your input. We need to have some questions answered by you, because there are certainly concerns, and we call it the scoping of the document. scope of the protocol of compensation. What some transaction technical changes include? Do we deal with all types of land? Is it only rural agricultural land or also peri-urban land? Is it only, let's say, certain countries, developing countries, for instance, or should it include all countries in the world? Should it also include situations in developed countries? We look at, we need to look at the impact on people, and we look at the effect of people. We will only need to deal with certain cases, certain groups of people. And then there's also the identification of target use. Who will use this protocol in the future? Government or NGOs or everyone. And how does this exercise to develop this protocol relate to already existing legislation and already existing guidelines? We know that there are certain guidelines that touch upon compensation, but there are also some different perspectives. Right? The Food and Agriculture Organization has this guideline, and there are some business organizations that develop these types of guidelines. The Federation of Surveys has valuation guidelines from 2013. Correctly, and these guidelines are all there, so we need to know how this protocol relates to this already existing body of knowledge, rules, and regulations. Now, this exercise of fair compensation is not in the first place aimed at public purpose or due process. But both prerequisites are important for fair compensation. So, to what extent do you need to include the prerequisites for expropriation, for fee, public purpose, and also due process into this document? To what extent these two prerequisites are also important for fair compensation? And then the way you develop this protocol, you can make it very general, but at the same time it might be very vague. Or you make it very specific and try to categorize different things that types of expropriation. So then it might get a very long book, like 200 pages on all the different types of expropriation cases you can think with and all the different indicators and requirements you would write down for them. But there's also a kind of question what path should we follow. And then lastly, I think it's important to recognize that such document is a living document. And with living document, I mean that it is a document that can be changed. That is not established and will not change. You need to be flexible that the rules you achieve might change in the future, and that circumstances like adjustments in circumstances, or if the rule is not correct, that we just change it better applicable. And the notion of the protocol being a living document means also that it must be followed after establishing this protocol. Or maybe we shouldn't do it, or leave it up to practice. So now we identified at least 4 issues which are very important, and that is inclusion of purpose and process requirements in fair compensation protocol, changing and related projects, eligibility of informal rights holders, and finally collective tenure rights. And these 4 issues will be dealt with by Ernst, Andy, Jacques, and finally Björk. So what we're going to do is discuss the issue. Now, we'll start with a brief introduction, and then it's open to you to participate in the discussion. And this, of course, as I mentioned before, will all be broadcasted to YouTube. We start with the decisions, and also to collect the experts, the authors, special protocol, but also build an international coalition and set the governance structure for it. That's difficult, and it takes a lot of time, I think, and also involves support from different countries, but also from different organizations. And whether we succeed or not, I don't know. We'll see. But that would be the next step after this step. Then the developing of the protocol itself, the writing, the testing, and then finally the software implementation and public implementation. These are the next steps. So, before I give the floor to Ernst, I don't know whether I just want to a quick round of questions on this, and then I'll give the floor to Ernst, because it might be so that you have already some questions to be answered on this.
Can I ask you to speak up very loudly? I think we have bad sound quality. Yeah.
But maybe let's
Speak into the microphone.
maybe a question for the benefit of us all. Timetable. Yeah. Timetable. The time frame, I think it would be the second step. Let's go back to the to this slide. The first document, the inter document, we started to work on it in April, May 2016. So we are already 6-7 months ongoing. I think that for the groundwork we need 6 months. Shaping the protocol, I think it needs another 6 or 7 months. And the operationalization will take, let's say, 8 to 10 months. So I think in, let's say, 1 or 2 years, maybe in 2 years, yeah. But this is a very rough estimation of how we will proceed and what time it will cost to do this.
Thanks. Yeah, could you explain a little bit more about who the document is for? I see that I think really that is in the document. The request for a more consultation principles for who and
yeah. It comes a bit from this multi-stakeholder approach. That this is a document that must be supported by many stakeholders, many great variety of that deal with that, not only government, but also companies and investors. And in this multi-stakeholder dialogue in the Netherlands, often noted members, for instance, research institutes, but also banks. And also, for instance, the APG, that's the Dutch biggest pension fund, because they lend money to people, to enterprises, to investors in the country. So they are in a position to more or less enforce these structures. And it is important for us to get the support of these institutions also to make it really enforceable. We don't have a world legislator that can be asked to develop a protocol that is applicable and binding in every country. It's simply not there. And because of that, we need to find alternatives to make it as effective as possible. And that's exactly the reason why you need to stay. And it is, I mean, it's difficult because you will, as we did the last year, you will come to all kinds of difficult discussions on the issues of businesses and the issues of organizations. But still, you need to have these discussions in order to get a consensus on how fair compensation should look like. And it is this difficult path we want to follow to at the end achieve this. And also to make it applicable. And we know that there are other guidelines and other types of issues that follow that path and are indeed very effective. So we try to do it also here. And we, of course, need to build on the existing knowledge and not duplicate something that's already there. But just add it and maybe make one comprehensive protocol of fair compensation.
Even when the protocol is completed, will it be a document that in a specific expropriation case can be handed up to a judge and say this is international practice? It may not be legally binding on the judge, but it could be very useful persuasive authority in formulating the judge.
Exactly. This is the country. It can be used by companies, but certainly also if there is a court case. And if the judge comes with such a problem and seeks guidance on how to judge and how to evaluate things, then this might be a document and also when evaluate points, then this document can be used by those evaluators to do the job. And that is, I think, added value to what we already have. To have this comprehensive approach to this problem. There's another question.
Insisting that you can't state that the issue of societal values is changing over time. And the debate must happen at lots of places. This protocol is not constrained. The broad debate on how from time to time determines what is just considered, when it raises taxes, when it takes the property of its members. And I insist that there must be space for a very broad interpretation in the debate. Yeah. It might be that in one particular country, international tribunal, African Commission must say no compensation is payable in other circumstances. The community must be compensated fairly. The other places. And I want to ask whether there's enough space for conversation with me. Would it be right that after the Second World War, there was a tax rate of 90% on the Now that was a moment in society when society could handle that kind of cost. Now, we must not allow a protocol to say that society cannot make the necessary.
Yeah, thank you very much for that remark. I want to say two things. The first thing is that I think that the conclusion of the last debate is that expropriation must be contextual, must be seen in the specific circumstances of the country, every region, the place, the type of project, etc. So one of the outcomes might be that we have to break down all these cases and try to categorize them. And second remark would be that, of course, these are only guidelines. But you could, for instance, adopt the rule, comply or explain. And that, of course, if a certain case is not fitting one of the categories, and then, well, maybe you could say we deviate because of. And that might be a way to deal with the problem that it is virtually impossible to, let's say, shape a protocol in a way that it will cover all the possible cases in practice. And I'm aware enough to know that it is not possible. But if there's nothing at all, then it's certainly not such a good situation. We need to have at least some guidelines, and it could be stated in the protocol itself how to use it. Please.
Just added to that, the way you derive the envisioning software is that it can, I'm not sure how to agree, it can be full of lots of options and examples. There's nothing like learning like, oh, this could be done this way, look at how this needs to be a little bit better. So that it's quite, gives you lots of different possibilities. I don't know if that's the rule, but many, many different ways to deal with different situations. And I hope also here that when it comes to the actual protocol, that it also can come out in versions that are very directly relevant to certain constituencies. Quite frankly, I know very few slum dwellers who are going to read their document or people. But it's so easy to take out the key points and to massively distribute. Please not at the multi-million-dollar expense that you need to do this in the but you don't need to treat some of them as such an expensive exercise and complicated.
No, but thank you very much, because I think we have to follow another route to make this happen. I should also mention the last thing, this living document element is very important, because by looking at it as a living document, it means that you can change it and you can learn from experience. So I don't know how, but this would be a better approach than just stick to the original version and say this is it. If that's, if these were all the questions, then I'm happy to hand the floor over to Ernst to start with the questions.
Thank you, Leon. Ladies and gentlemen, my name is Ernst van Leyen, in Johannesburg, and I am chairing this first discussion session of ours this afternoon. If you are going to contribute, I just ask you that you identify yourself and your contribution to the purposes of the recording. So the first topic of today is options for the inclusion of purpose and process requirements in a compensation project. Now, purpose and process requirements for calculating compensation expropriation relates to the substantive requirements for an expropriation, because merely paying compensation cannot justify an expropriation. One needs a valid purpose to justify the expropriation, and the way in which the expropriation realized, the procedure should also be a just and fair one. I would like us first to discuss issues concerning the purpose. So, first off, as I said, the purpose concerns the primary justification for the expropriation. So we can discuss how broadly we want to define purpose for purposes of this protocol. Do we limit it to the eightfold public purposes of building roads and streets, or we also include public interest to realize land reform, that basically also then includes the dangers of what like a kilo type case where you project for economic development purposes. In this regard, the purpose also relates to the question whether some purposes should justify an increase in the amount of compensation. For instance, in Sweden, and I think Ireland as well, if a home is expropriated, the amount of compensation is increased by 20 or 25%. So if you could discuss matters concerning the purpose of the expropriation. Yes. Any suggestions on how to approach? But
Yes.
Maybe perhaps it's better that you can go around.
Yeah.
As I said earlier, I think that the purpose and the process are kind of inherent part of compensation. I mean, if we don't accept compensation as monetary compensation, and this is the only option, because if this is the case, so all the protocols kind of redundant, because if we are accepting fair market value as the only suggestion for compensation, we might actually escape this entire session. So I think that the purpose and the process are really important. The purpose, as you said in keynote, for example, or in language one, right? This is changing, I mean, the focal point of view of the compensation. So not ignore that there are purposes that actually can affect what we want to achieve by compensation. But as I said earlier, I think the process is much more important. And the process actually can become part of the remedy. I mean, if we change the terminology, we want to speak only about compensation, but speak only about remedy. Right? So process can become part of the remedy. And if we will manage it right, if we will try to determine the right process, it's not only a few processes, some kind of, I don't know, I don't really like to use the theoretical processes, but if we try to, to expand the negotiation and expand the information, and actually try to involve the owners and all the other parties that stakeholders that Leon just mentioned before, I think we might be able to turn this process into part of the remedy and then directly affect the compensation. We can say, as I said, that a lot of monetary compensation, money is public money. We can say it will instruct differently.
What's your perceived knowing? I definitely think that we need to something like income. But I think Hank just said we need this protocol to be flexible enough. Once we start playing with the substance as the purpose, we interfere a lot with the competences and powers of the national legislature. I mean, that's at the democratic core of legislative powers to decide which happens for which purposes we can work. That's why I would suggest that we rather look at the procedural and governance aspects. And I would like to add to what Shai just said. I think we should take a look at what the role of the legislature is, in particular, how specific the purpose needs to be. Because I think that once the purpose is more specific, it also enables the judges to apply this new purpose to the case. This way, the judges can provide better judicial protection from arbitrary expropriation. Whereas if public purpose just remains public purpose in the legislation, the judges have a strong inclination just to refer to the judgment.
Yeah, I'm trying to move forward. Yes, no institution, homeless. This says, no. Okay, I just want to raise one question that's probably a long time, right throughout this process. There seems to be an implied presumption that public purpose equals necessary public ownership of the land. And one of the things that I think we have to break open is, do all lands, all resources set aside in the public interest or for public purpose have to be owned by the state? No. And if we don't crack that one open, we're just sort of reinforcing and entrenching this notion. I mean, I mentioned beyond the lands that the only law that I know on this continent, for example, which has taken a progressive step on this, is to say that public land, i.e. land that's earmarked for public purposes or for the public interest, can be owned by a community, by a local elected authority, or by the central state, or by state agencies. And one of the biggest issues that I'm seeing of this kind of war between public land and, for example, community land is precisely the trying to, it could be overcome by saying, by throwing open, this would not be presumed, and a very critical part of the process is to determine this land is going to be set aside for a school, a dam, a protected area. Does expropriation have to into the hands of the state have to occur? And if we don't address that, I think we just reinforce the So I think over what I was saying, the process is absolutely fundamental, but we can also cover these issues in that process. Anything else? I would like to bounce a question back to Shai about. I would like to ask Shai why the idea of the therapeutic process is being dismissed so quickly. I think there's something to be said for therapeutic process, especially in the process of divesting somebody from ownership and calculating the compensation required, and it might provide some of the solutions to the issues that we've heard around market value and low market value and less than market value.
Okay, I read. Okay, so try again. And the answer is not really substantial. Actually, I think that because we will speak in such a document will be kind of denied by the financial stakeholders and legislators. It will be difficult, to really enhance this project if we will start to talk just in all kinds of mushy terminology. I mean, we need to speak. We need to do it in a way that the legalists and in a way that the economists can actually accommodate. Okay?
I'm not sure. I'm not sure they're saying something, and that is, I think there should be an exclusion towards the purposes, and that's economic purposes. I think there's a very slippery slope there. I've been to several countries where they articulate the purposes quite precisely. In Azerbaijan, there's a minor hiccup insofar as they do not have parks as a public purpose. But what kind of coordinating businessman needs the state to hold his hand in these consolidated parcels of land? If you have someone like that, how successful are they going to be with the rest of what they do? As far as businessmen are concerned, if they can't consolidate this right, what chance have they got? It's not the state's job to do that. And so that's something I would be very chary about looking into that purpose.
Thank
background on go back to the point made yesterday. One of the speakers said that you just have to have no point. So at a certain point, the decision has to be made appropriate, and that the reasons for that will be the alternatives to use some of them are much better capturing the value of the benefit. I almost want to judge someone that he or she can ask, why did you like to do that? Why did you do that? From another angle, we work at a particular capacity of the function where the biggest item on the budget is the population, because it's so high, it's the biggest item on the municipal budget. So they are desperate for other ways to find consolidated municipal services involving. I think in finding on the issue of expropriation, keep in mind that one number of things in some context region doesn't actually keep
Thanks very much, Katie. I have 3 points. The first is really just getting back to Lynn's earlier point, which is I agree with her about the need, and it speaks to those as well, the need for examples of alternative options here. And one of the most important functions of this reform is pulling together a knowledge bank of techniques and the success or otherwise of techniques. On the issue of purpose, I think I agree with Connor's point that exploring the idea of the therapeutic process is something to look at, and I think it speaks to a more general point, because I think this work needs to be grounded in empirical work on the question of impact and the question of impact of expropriation on those adversely affected, to the extent that there is empirical work, for instance, on the great impact of expropriation, etc. That's something we need to be looking at, because I think we need to, in looking at possible proposals, always have an eye to impact, and not just impact in terms of statistics, but insofar as we can get behind that to the real impact on communities and individuals, that we need to at least look at the work that's there on that issue. And there is some on that already. And finally, just a general point on the proposed title for the input document, which just in the context of whether or not we should be including purpose and the process, I think we do have to, but I could see a potential issue with having a title to the protocol that specifically refers to fair compensation, but doesn't explicitly reference any additional requirements. So if we are having an argument that there are 3 requirements for legitimate expropriation, I think that needs to be reflected in the title, or fair compensation isn't explicitly referenced in the title. It's just about legitimate land tenure change. And I think we will inherently skew the priority of the 3 requirements in favor of compensation as opposed to purpose and process. It's only compensation regardless of what's said in the body.
Yeah, sorry. You can do one. You're after the procedure.
Sorry, if that goes on the brief for I wonder about what Aaron said before about making context to this protocol. And in my view, one of the issues that should be considered is what is the relation between this protocol and the legislation. I mean, would it be part of the legislation in the future, or that is a way of interpreting the legislation? So it's not clear to me. It's a question that maybe cannot be answered in advance, but should be in mind. What are the relationships between this protocol and the law of the land? Which means that if the law of the land in the Netherlands actually defines purposes, maybe we should define purposes in the law of the land and vice versa. So, I don't know. This is my thinking about this relationship.
I add something?
Oh, absolutely.
Because I've read the voluntary guidelines, and what you described is exactly also the difficulty with the application of the voluntary guidelines. Because it says it deals with legitimate tenure rights. But what is legitimate tenure rights? It has to be conducted according to the law of the country. And there you go. There's no central explanation of what such means. So yes, that's a problem, and we need to address it. I mean, the Volcker guidelines didn't address it because they just gave it as a guideline, and you do whatever you want to do with it. And that's, of course, a problem. But we hope that by using this multi-stakeholder, by using companies, by using banks, pension funds, who are really can make a difference. In fact, that implementation in a decent way will happen. I hope this is the correct thinking. If you follow the other path, the really binding treaty kind of a ruling, then probably in 800 years we will not have it. A sufficiently effective tool. That's the problem. The alternatives are something that I know is really effective.
Well, I'm expecting for the conversation thus far, we are a little behind time, so I'd like to move over to the procedural requirements for expropriation. We have touched on some of these requirements so far. Get the debate going, I'm going to mention a few issues which I picked up from the papers over the last few days. And this, the first concerns the procedure that the prevailing authorities follows to expropriate property, namely whether we want a uniform procedure and whether we want to differentiate the instances where the object of expropriation is ownership of land in your main public expropriation cases, and also then if the object of expropriation is customary law rights, which are not registered and which are more difficult to, or the procedure of expropriation is outlined in MENA. The other one is what kind of factors should be set up in the process for calculating compensation. Should there be something like the factors in the Constitution or the factors that they should put it out in learn paper yesterday, or should we look over to the particular jurisdiction to identify factors? Any thoughts on these factors?
Thank you, Ernst. I think one of the suggestions that I would make is to divide the procedure into a planning part and an expectation part. I was talking to colleagues of ours who were doing this thing, and I heard about a project that was prepared to complete secrecy, and then suddenly the state approaches owners to acquire the land and necessary expropriate. So to plan a project with a participatory procedure first, and then to think about land acquisition would make the protection a lot more effective because if you think of it, if you prepare a project with secrecy and complete the preparations, you may or may not get going to change their plans. So it's very important that the planning is done in a separate procedure and the participation starts as early as possible.
Anyone else? I have ideas on this conversation.
required to decide the equipment source and then afterwards on the decision.
I think about participation, so the question then you present there is a major issue. Because you have somebody who's on the board with the union, often that is not the case. So how do we make sure that all different groups within the union are well represented?
This is only because I'm talking about the whole principle is that the person can go off and buy land. That is the same quality as the land has lost. And timing is very much of the essence in that regard. So the point should always be looking at the person who's using the conversation when they've been markets in a state that conversation can cover before or after principle evaluation. And so that can be very problematic sometimes. Because, for example, it might be made for years, and then people put a CPI on it, but the market doesn't want to have a CPI. And so the whole principle is destroyed by the time of compensation.
I want to begin to tell the story about the suppliers for the profit, compensation. And sometimes the community and from payment into government funding, there's nothing to do. Getting years after the event is a good example. Huge number of consultants insured now we're going into the third round of third phase.
Getting more at it.
Sorry. I just wanted to reinforce both the understanding of the segment. Actually, when I looked at the African constitutions, only 16 in the whole backbone, except for having required prior payment of compensation prior to the election. And it is a major issue, not just in Lesotho. In Ghana, not millions, but billions of cedents are outstanding. Sierra Leone, Liberia, everywhere, Nigeria, it is a massive problem. And I think there is a general principle, maybe it has to be across the American government, but I think when you come to agrarian states again, this I think relates to what Liam was saying, maybe, I see grounds for a lot of general principles that are globally applicable to laying out best practice. One of which, quite frankly, in Asia and Africa, has to be prior payment, prior to but those are all laid out, but then you reinforce it. But, you can cut the cake, I think, industrial economy and these are really big issues. And I also think, really, and so many of us have said it was 24 hours. This process is really where I think a lot of I understand why the vote has excluded, so it's a let's presume public purpose, let's presume due process, but if you can somehow bring them back into the process and completely, you're absolutely right, don't find it. And even while I'm just looking at their new revised PSS 10 on procedure. Not even, not quite there, but they're getting to say, planning of the project must happen as early as possible with tech people. Quite frankly, I can't think of a single public purpose or public interest project that should not begin speaker.
No. Colleagues, thank you for your participation. I think we have to move on to the next topic, which has been chaired by Andre, which is on tenure and delayed projects. Andre, over to you.
Thank you. I have prepared a few slides just to guide the discussion, and I'm just going to have to put this down for a minute. And so just want to read to my notes. My name is Heidi Norton. I'm from the University of Cape Town, and I'm supposed to guide a discussion around changing and delayed projects. We're going to do this as a slideshow. In the beginning, if you look in the protocol, the draft protocol around page 30, there are some questions. And the one I think that this particular topic feeds into is question: which of the due process and genuine public purpose problems should be addressed by a fair compensation protocol, and which one should be left out of scope? So Aaron has already introduced that, and then the protocol goes further and identifies some topics already, and the delayed project, or what to do when the project is not implemented timely, that becomes one of the subtopics. So Ron and I and a student of mine, we've already published on this, and I just want to acknowledge the fact that a lot of what I can guide you on comes from that, and especially the very good comparative work that was Bjorn's contribution to that. And I also want to acknowledge Louise' questionnaire that she posed to the students in class, the worksheet for the property board, for the expropriation board lecture on change of purpose. I'm going to use some of those questions as well. Thank you. So the expropriation process, and this is the first question, especially because we have people from several jurisdictions. So perhaps we should start here and just talk about how generalized this diagram is of the expropriation process in particular countries. If we say that generally an expropriation process starts with an inspection, which evolves into a consultation process before the actual decision to expropriate and the notice to expropriate is given, and that the compensation happens after that meeting. How true is this for the context in which you work? Okay? So I'm going to give to you first.
It is correct that the individual district going to be prior to all of this generally happening, and most of these issues will have gone through more or less the same procedure regarding compensation in the planning process. So before you can even get to the point of providing question arising as to notice and association, consultation, and issue of association, the land will have to be zoned for the purpose generally, and build the consultation, not just the adverse use, and any consumer interest in that proposed zoning, and then that may be consultation. But just be aware there, there are situations in which that won't arise. For instance, if the proposed project doesn't involve any change of zoning, there's implementation of consultation regimes where there is a planning process.
Thank you. Just follow up on the recording on the session. Okay. Did you get it all? Yes? No?
Yeah, I think more or less only repeat what Rachel just said. But it depends.
if does this process include the type of the project or not? If it does include the type of the project, consultation element is way too big.
Thank you. So Rachel was speaking for the Irish context. I'm not sure what context you were speaking for.
The whole.
I think such a point was. Would you?
Which is similar, in the layering of the planning process and the purchase process, purchase happening through the and conservation potential judicial review.
Thank you. So we have both from the European continent and from the this process is actually this depiction is actually a way to simplify for what actually happens. Can we hear from Israel?
So in Israel, actually, we have a new law from 2010 that established the consultation. There is a committee that hears the expropriation authority after it makes an inspection of the area. And it comes to this committee with either a member and presents why it should expropriate the land, whether there is a different way to do it, what is the plan for that land. The authority of the committee is only to recommend to the Minister of Finance whether to expropriate or not. But usually when you recommend to expropriate, you sign it, and when you don't recommend to expropriate, you get it back. No, but it's only a recommendation. We do not decide, and then the expropriation process starts, and of course afterwards there is the issue of compensation. And to emphasize that the consultation does not refer at all to the question of compensation, only to the legality of the expropriation, proportionality, whether this land is needed, whether there are other ways to do that, how to do it.
Thank you very much. Nina?
This part of that, as I understand it, only pertains to the process once the decision is expropriated originally. In terms of the decision about the public purpose, those files and other legislation, municipal planning, or through an environmental regulation, whatever it is, each of those sectors has their own consultation process in terms of how to deal with the purpose. This goes, and certainly it's clear in the proposed act, is their own truth points how much. And again, there's a direction that the proposed act or the person in the current legislation is that at the end of that there's a second opportunity for compensation of people who fell outside the net of that original inspection and consultation that's designed to identify the real people. So under the law of the legislation, this country, including the environmental and planning and exploitation legislation, is designed as framework legislation about the process rather than to actually be content. And in terms, sorry to take a step back, the previous discussion about process and protocol, in many words, about a very explicit framework approach rather than specifying exactly how exactly you can accommodate some protocol guideline. Thank
you very much for that contribution. I just want to check with the rapporteur. William Kirby. Was that going to speak slower? Okay. All right. Okay. I would like to move on. So this is just get us loose. All right.
I think we do need to be aware of in both certain areas. The first thing that will happen will be an negotiated and so prior to engaging the formal processes for expropriation, the expropriation authority will write to the homeowner and look over usually quite an extended period of time to negotiate sale outside the statutory framework entirely. And so this will be a last resort and minority.
Thank you. That is very good.
I'm going to, do you also want to say something about the Netherlands here?
No, no. What what I want to say is that if you put this consultation phase very early, this will instantaneously affect the market. So you need to be aware of the fact that this might affect the market in the way that it will do. So you might also be aware of mechanisms to apply to prevent that happening.
Thank you very much. Okay, so this was just a conversation stimulator, right? So I think what comes out of here is that the awareness that there is a need to expropriate, there's a public purpose, motivating for expropriation happens before this error starts. Yes? Okay, so now the question I'm actually supposed to deal with is what happens if that purpose that was identified to begin with cannot be executed, or if the purpose for which the process had taken its course eventually turns out to be a non-stop. So actually, when we're talking about consultation and where consultation takes in the process, this shouldn't be happening, right? But it seems to me, I mean, Bjorn has done an extensive study of many countries. He didn't do Israel. But it's done an extensive study of many countries, and it seems to be an issue that is dealt with differently in nations. And I want to show you a little bit of that. I'm wondering where I should look at a particular example. Do we have time for that? You think it's unnecessary? Okay. So this is what Bjorn has done. He has gone and analyzed the situation in of how the law deals with the issue of change of purpose or delayed implementation of purpose in various countries. And he has found a spectrum of responses that we then went and put into a grid by looking first at to what extent does the law in particular countries allow for scrutiny of the change in purpose, scrutiny of the fact that there is a delay, or that there is a different purpose that can be fulfilled, and that is on the horizontal axis, and to what extent the law, when it allows or not allows that, to what extent the law imagines the right to retransfer or invalidation of the process. Either there is great sympathy for that, or there is no sympathy for that. That is the horizontal axis. And based on that grid, that matrix, we then went and took this information from various countries and positioned different countries in different spheres of the matrix. Now, would you like to say something about this? About your findings?
If it's clear from here. This would be well, I think at the one side of the spectrum, we've got the United States, for instance, that do not offer a right to reapply unless the authority acted in that way, and they don't care whether the purpose changes or not, unless the authority is acting in that way. And then we've got basically different jurisdictions of France and the Philippines that grant a right to reapply if the new purpose, if the proposed new purpose is not, that will not constitute a public purpose. So they do recognize, okay, there might be a right to reapply, but if the new purpose is a public purpose, then there won't be any right to reapply. Then we've got the use of patriotism. We've got the Germans who say that if the project is not implemented, that there will be a right to reapply and there is minimal rights to change the purpose.
Just a question. Is there a time frame for the development or not? The time frame for the analysis and then there will find big differences in that.
So in the Netherlands, it's generally 3 years before the constitution expropriation act. In Germany, for example, the expropriation act itself, for example. And there are different choices as to who determines and how much time.
I would ask you to indulge us by using the matrix and then asking for those of you coming from countries that you did not include in the analysis, where do you think your jurisdiction would fit in England? Would you like to say something about that? Or?
Well, I was going to just comment on the reaction.
Okay.
So just add a few more countries to the comparison. Offhand, I remember looking at India's new land acquisition act, I believe it's 5 years, and it's only if the land is completely unutilized, then they would grant the acquisition rights are granted. And then in some cases, like in Bangladesh, as I recall correctly, the land, the change of purpose of the project doesn't go through, the project's abandoned, but the land actually just goes back to the government. This is the case often in other developed countries where the government can decide whether or not to then sell it to the owner again, but it's not an automatic reacquisition. I think it's another potential issue is that it goes first to the government, and then maybe you have a right to first buy it from the government if you're a protected owner, but it's not necessarily thank you.
Going to Israel first and then I'm traveling back to South Africa.
So in Israel in 2010, the authority didn't have to integrate in the expropriation request what time to implement the project. And that caused delays of 25, 30 years. I question whether this is a delay, and the court are highly reluctant to regard a 25 years non-use of the land as a delay, saying, there is always the need for public land for public uses, and it's very rare that the land will be returned even though after 25 years it not used. In 2010, the law changed, and now the authority needs to specify what is the implementation project, the process of making the project. And this is not an easy question because it has a limit, it can specify up to 15 years. Now, making a playground shouldn't take 15 years. So whether it uses its discretion in good faith or not, it's a question that didn't reach the court, but it's a question that we have to think about. Now, if the land was utilized for one public purpose, it can be changed with no right to return to the owner to another public purpose. Okay, so you can just from one public purpose to another. You have to notify the owners that that's all. But if it changes to a private purpose, which is a big question, what is private and what is public, but in fitting that question, the owner has a right to repurchase the land according to its current value. I look at another segment of this issue. Sometimes it happens that the authority takes more land than it needs in action. To take like, the authority thinks that if you make the road wide, and it became narrow for many reasons. So the question is, what do you do with the remainder of the land that was not used for this public purpose, although the public purpose was implemented by and large? So we're having the new law and arrangement that if the land was not used, we have to return it. We have to notify the owner there is a land that was not used and you are eligible to take it back. A point that needs to be taken into account that the owner, unfortunately, gets the land back under its new public designation as a road. When it was expropriated make the road, but it gets the road, right? By taking decisions.
So it opens a completely new can of worms, and it seems that this is what we also do. There's an absence of scrutiny of the new purpose that is problematic. If there is silence on whether there's a right to be transferred or whether the expropriation will be invalidated, that is also problematic.
Thank you. I would like to make two comments. One is that what I missed in this matrix is also a possibility in the Netherlands that when there is a change of plans, you don't only have the right to retransfer, but you also have the right for additional compensation. For example, where the specific purpose of building four-story office building, in the end they built 6 stories. The compensation is based on 4 stories only, but the value of course higher with 2 stories extra. In those cases, people say, well, I don't want to retransfer my property. I just want extra money, and then we can get away from that. I have to raise tax. Yeah, maybe with the land bank. Yeah, and to add what Chris said about the fact that some projects are delayed for a very long time, I think that those for the situations where expropriation has taken place, but actual use of the land storage because expropriation has not taken place. But I think another problem is also with delays. In situations where certain lands are, so to speak, designated to be expropriated, not actually expropriated, but expropriation, then hangs above that property for also maybe decades, and that the value of the land, the potential sale of the land will almost be impossible because nobody is going to buy land that is designated to be expropriated. I think that's also a problem. Remember, before the damages that are caused by these about shadow damages, because the shadow of expropriation is hanging above the land. And while we are difficulties of coming up with ideas how to deal with those damages, because we can see and establish that there are damages, how to be clear enough to say that, and how to
I have dealt with the land bank. I want to continue with the situation where a cloud of expropriation enters the property, and specifically in the land reform context. The rights of labor tenants and the formalization of those rights is a constitutionally clear. The department asked for claims to be submitted, which happened 30 years ago, and they dealt with very few of those claims. The rest in there. Now what is it? The labor tenants don't want it process cancelled because they want their land. The land claims court very recently, and by very recently I mean yesterday, issued an order imposing an obligation on the department to lodge a timetable on when they will deal with these claims, with an annual deadline of how many claims must be finalized within a given period, with an outside person, which was called a special master, if that comes from American law, to supervise the whole process, make sure they comply with the court order, and report to court if they don't. That is a method to deal with delays, and event methods which could be recommended to the protocol in suitable presentation.
Thank you very much. I think what you touch upon is the importance of a good governance process, also of the post-expropriation period, and then how to yes,
the governance of it, the management of it stays in and relevant consideration. Yes?
Just the UK and Irish situation on this is very much down in the Parliament and Parliamentary, so there's no possibility of government for anything and no certainty of change of purpose to the extent that ultimately if people in the party decide not to proceed with the project, they can easily just sell the land on to a private developer and put the profits into their general coffers. And really what that turns on is the fact that as part of this issue in both jurisdictions will be what does the statute say that purpose, the power of acquisition is usually in the generally those powers are very broad in nature, so the purpose of acquisition is for any planning purpose. And once the local authority can point to anything within that ambit, even if it's different to what they stated was their purpose at the outset, that satisfies the criteria of the statute, so you can't challenge the expropriation of calling anti-barriers. So it all turns on the fact that the statutes are drafted so widely giving the power of expropriation, and the court won't exercise any scrutiny over very broad purposes being written into expropriation for this to make things together.
I think that speaks to one of the insights we also had, which is that an expropriation as a form of acquisition of ownership, acquisition of ownership, it's no ordinary acquisition. It carries the origins of this form of acquisition with it into a new ownership dispensation. And so what you are describing there, in terms of no scrutiny of the change in purpose, no country transfer, this we found to be particularly problematic. The South African situation under the current Act is also like that, in that there is simply no provision for it, and it creates really unjust outcomes for specific cases. So now to come to what is supposed to, and I'm very glad Jacques spoke about it. Do you have any questions? And the possible responses. The compensation paid by a former owner. If there is the possibility of retransfer, how to calculate the compensation that the former owner must pay? This is the one question. I'm just going to throw both of the questions out to you, and you can answer what you want, because I don't think we have lots of time. Please keep your time. Okay. We have time? Actually, no.
About 10 minutes.
Oh, okay. And additional and should this not be implementable? Should the state be paying additional compensation for the fact that it actually had not gone through a proper consultation process to decide to come to the finding that expropriation in these circumstances would not be the right solution? So I'm leaving those two questions to you, and you can answer whichever you want to, and the rapporteur will organize it in the report so that it makes sense.
Well, I think that, in my opinion, the good system consists of the former owner having the choice what to do, because especially if there has been a long period of time between the expropriation and the moment, which is clear that the purpose will not be carried out. It's certainly not possible that the owner in question is moved somewhere else. For example, there has been government use of farmland, and maybe as well there's some farmland elsewhere. If the only right to have property, the part of property that does not have the same kind of good as property that we lost. So I think if that is the case, you should not have the option to say, well, I don't want to get back up to some additional compensation. Of course, have the right additional benefits of the fact that it doesn't have to realize. And it includes the first one, the requirement of property, and the reasonable and complete part will pay back
very much. And I have another question, and that is what if, as the case that we heard from Israel, the other candidate of that, but it's useless in the form that it's written. What if?
And in my system, that would be provided for by the fact that in that case, the owner would say, I don't want property back because it's useless. It's going to be compensation.
Thank you. For the purpose of not invading a certain person here who has a certain consultant, I will not mention that this professor's name who's worked in Kenya, Tanzania, Uganda, Rwanda, Zambia, Zimbabwe, Botswana, Lesotho, Namibia, Swaziland, South Africa, Malawi, yada, 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 and many other countries. Now, in one of these countries, he introduced a law to do with acquisition of land, and I will pass it on to you, Leon, so you can have a good look at it. And there's about delay, section Article 51.1. Basically said, in case of implementation of actions specified by present law to ensure ownership to acquired land is detained by acquiring authority and delayed 1 calendar year after sufficient notice of ownership, then the acquisition of that land shall be deemed to have been abandoned. 1 year. The time flow on delay is in cases where the paperless land acquisition process was lodged in court. Now I mentioned that how many countries this person has been consulted, because this particular article probably quite well spread within the number of countries that he's been. So it was very tough on the government to get back together and perform the tasks that they were otherwise it's just entirely. They had to wait 3 more years before they could try to apply the same amount again.
I wanted to ask, I didn't understand your comment about whether the land was first designated for 4 floors and then it became 12 floors. How does this affect the compensation? At least in Israel, the compensation, the base for recognizing compensation is before the expropriation, and regardless of what it's going to be. So maybe I didn't get it right, or
at which the compensation should be fixed at the actual moment the property is transferred from the previous owner to the expropriating party. That's the ultimate compensation. And if at that moment, that is usually the case, and say farmland has been rezoned for housing estate purposes, which is also a purpose for expropriation, and the owner at that moment, farmer, will get this, the fair market value will be based on the fact that according to the zoning plan at that moment, the property has a value that is valued at housing estate and not as farmland. Yeah.
Okay, so here are a few additional questions, sub-questions if you want to. Under the compensation question, what if under the original expropriation compensation was received for loss of income or for relocation, and now the expropriation is undone? How should that be treated? What about legal costs to effectuate the expropriation or the claim to be restored to the original position? Should that be included in response? What about improvements that were made to the property? What about devaluation of the property in the meantime? The property had laid fallow for 3 years. What about that? How should this be dealt with in a regime responding to delayed implementation of the property?
Thank you. Yeah, I'll respond to your question about financial laws. I mean, I think that even if, let's say the delay is ongoing for a year, I mean, during that time, there's significant financial loss that can be incurred by this landowner during this time. So I think the compensation should reflect economic activity associated with the land. And yeah, I mean, I think you have to look at what the land is used for, look at the business record for a business, so what is typically generated within the year. But I think that should be reflected. It's one of my indicators as well. Whether or not companies reflect economic activity improvements and other types of values. I think that always actually comes down to the question whether it's what we preserve that nuclear development of the land or actually cut. These are the core of the development plan. No, 95. So we actually determine the expropriation reserve the relationship between the owner and the land, the real and relation, and then actually the lower part of the model creating. But I actually don't think it's the proper way. I think that's the American way, which once you feel your commitment to expropriation, you're realizing the expropriation. We need to think whether we actually want the owner to stay in the picture. I mean, I'm not sure it's a good thing that the owner will stay in the picture because you can come to ridiculous consequences. If we build something or we did something on the land and now it's no longer used, like an education institution, for example, and there's no longer children in this land. So should we return the land to the owner? I think we should, in a way, think about making, the cut.
Right, having a clean break is one way to go. But sometimes I think the argument for a clean break proceeds from the premise that the state acts in good faith, and that the state can be trusted, and that is not necessarily so in all countries.
Yeah, I want to continue your point, Henry, because when I teach expropriation in class, there is always resentment against those cases of delay and unit. And I often ask myself, why don't the students resent against the act of expropriation itself? I understand that sometimes, they're called out, and when things get wrong, and you don't trust the authority at first, and you also experiencing really invasion of your autonomy, property, you're getting very sensitive for what is going afterwards. So I think it's a built-in tension, making it clear maybe before, and then not show the participatory process to deal with those issues maybe, but it is not really, something that you are feeling that you are agreed to. It's very difficult to say clean up afterwards. So I think that's part of the tension.
Yeah, I would like to comment on what Shai just said. I don't think that a clean break is really the right thing to do. Because just imagine how illegitimate this expropriation must feel. Because it's not good. How would you feel? Even though you found a new home. Oh yeah, my new home, my old home is demolished, but there's still no shopping center in school. So I think, I'm not saying that there should be motivation to reapply application. It's an option to choose between reacquisition, which in such cases that nobody wants to do anyway, and additional compensation.
It's also possible that the solution has something completely different, not an expropriation boundaries, which is to hold the state accountable for the decisions it's making. If the public purpose is not implemented, the decision was wrong to begin with. It wasn't well informed. Yes? Suppose we stop and now I want to reinforce what. Yes? Okay. Reinforce what you're saying. You know, if you look at, there really isn't, I think this is a case where different circumstances apply. Quite frankly, most countries I know, to be able to take the land, and you never take property for it anyway, normally, it's just, they do not have to return it. If you pay a fee, it's like over-invitation to take as much land as you want. And also, when you think of most situations in like the prairie states, people don't leave, they get pushed to the edge of the property, they still live immediately, it goes on and on for years. It really is very viable that that property is returned. The problem is that they have to pay back the compensation they received in order to get the right. And there's some work needed on that because nobody's going to keep the compensation that they were given. I mean, they spend it in the shop. You know, it's not much. So, you know, I think we have to be a little bit careful on this. I really have to think of that lack of, I'm sorry to say it, lack of transparency, accountability is probably the line to work on. Not wonderful states where the government, oh, we really wanted to make a vote, but we haven't. Personally, I can be faithful on the parties. There should not even be a consideration. Now it's over. Sorry, it's over. We're going to have tea, and then we're going back to topic 3.
We're going to
I didn't know what you wanted about.
Oh, really? Oh, wow.
Okay, when you come here.
Why are you doing a follow-up? Because we have to. Oh, my God. So we can extend it.
Yeah, shall we do that? Absolutely.
Let's just have one. Let's go now.
Oh, yeah, we both done.
2 of us needs to go to back here. So I need to say that was but I did say it has the potential to become very realistic really realization force along Western world perceptions, and I think it's really needs to go spread. Okay, you should think about it about reference. Maybe even like the Israeli judges are doing maybe to decorate some kinds of ideas from.
we need to select.
No, just it's a suggestion because it's say maybe it's better not to say. Really? It's even worse.
Don't worry.
Nobody watches, huh?
He's worried.